I'm Bill Auten of Auten Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims adjuster.
Hi, Bill. How are you?
Good. How are you?
Very well. Happy New Year.
Happy New Year, 2026 already. I can't believe
I
it.
I know it's difficult for me to little wrap my mind around that, and I say that every year, but then there you go. That's what we have.
And New Year's gets here faster and faster every year.
Right? I don't know why that is. Speaking of getting here faster and faster every year, it's like we keep doing these things. Like, didn't we just do this yesterday kind of deal? And
The
I don't
unfair
know.
claim settlement practices.
Yes, and actually we kind of did. It was episode 76 with Heather. It was really late in the season for 2025 because you know me, I love a good theme, and usually on New Year's I want to set that resolution of let's do a great job and put Chantel out of the expert witness career kind
Right.
of a kind of deal. By the way, be sure to like, subscribe, share, comment, all of this sort of thing so that we could get more people listening. And, uh, if more people listen, then I'm out of a job that much quicker. So,
We want to
yay.
spread the learning.
Yes, spread the learning. Absolutely. So, the reason why we do this every year, besides me being a little snarky saying I want to put myself out of business, is because these are the things that will get you in trouble. And if you, of course, don't do the things that will get you in trouble, you don't get a lawsuit and your claims don't stay open that much longer. The claims will settle easier if you just take Bill and my advice and go from there. And that is one of the reasons why we do this every year.
It's kind of like a cascading effect. You want to avoid doing this on one claim to avoid that one lawsuit, but you want to avoid it as a pattern because that pattern is going to be pointed to in any bad faith lawsuit. They're going to say, "Look, you guys do this over and over and over. You do the same thing all the time. You've got this pattern where you are continuously breaking these rules, and you're doing it just to save money, and that's bad faith."
Yes. Yes, absolutely. And we're going to be talking about that. And of course, I've actually learned a couple of things. I went down to Dallas to talk in their insurance day, I Day, the CPCU I Day. And I actually learned a little bit of the history behind the Unfair Claims Settlement Practice Act, which I did not know. And it had always confused me. And so now that I know it, I want to share this with everybody because I know we just don't have just a few listeners. We do actually have more than 10, but they're all over the United States. And I also want to always point out that bad faith isn't always a claims issue because as soon as we start talking about quote bad faith end quote, we automatically, I feel that insurance professionals automatically go, oh, this is a claims deal and I'm an agent or I'm a broker or I'm an underwriter and I don't need to be paying attention to that. But I learned some of the triggers that agents can trip or that underwriters can trip. And that goes to the administrative rules of the Department of Insurance. So we're going to talk about some of that too, which we've never done. So this is kind of new in our new year.
Right
Yay!
on.
Yay! So, you know me, I love me a good definition to start off so that we always know where we're coming from. And I think that that's like the key point. So, again, just kind of reframing this issue is that negligence is a mistake is a mistake or a mistake is not bad basically. So if you've just neglected to do something once as a claims adjuster, by the way, that's not bad faith. Okay. Bad faith is a choice just like you were saying, Bill, you just do it over and over and over again. Like you consistently don't send out those 30-day letters, or you consistently lowball, or you consistently don't communicate, or you consistently deny a claim without sending a letter of declination or declination of coverage, however you want to call it. That sort of thing. And that's when we get into our bad faith. And so, who decides?
Who decides whether it's negligence or bad faith?
Yes. Yeah. Do you know?
The well, in New
As I'm
York,
putting you on the
it's been the
stand.
court.
Yeah, yes. So raise your right hand, Bill, and say, I solemnly swear. No, yeah, you're absolutely right. It is going to be in the court systems. It's that quote reasonable person standard or the judge that's going to be doing it, right? And so it's the trier of fact. So I remember very distinctly when I was a baby adjuster being told by the plaintiff attorney screaming at me over the phone, oh, this is bad faith. I'm going to sue you. Da, da, da. And of course, it's frightening. But now that I've been doing it for 25 some odd years, I know, oh, yeah, bless you. You're just trying to intimidate me. It's really the trier of fact. Now you need to know your judicial hellholes and that sort of thing, but there you go. So,
And when I was a baby adjuster, I always had a problem with my pacifier when I took a statement.
mm, mm. Did you mumble a lot?
I had to pull it out and find a place to put it.
Oh, did you cry? Couldn't do it in the
Probably.
afternoons because it was your nap time. Listen, let me tell you, nap times are nice. I gotta tell you. So yeah, so who determines these things is the judge and the jury, and almost every state has the either the Unfair Trade Practices Act and or well actually I think they would have both or and the Unfair Claims Settlement Practices Act. And if you don't have the Unfair Claims Settlement Practices Act specifically for claims, then everything falls under trade practices. And this is where I used to get confused. So this is the educational part of this that Chantel learned when she was doing her research for Dallas. And so originally, what everybody had done, like the National Association for Insurance Commissioners had done, was had written out the Unfair Trade Practices Act. And it mentions in one or two sections, like maybe line 15 or 16 or something. Don't quote me on that. I'm making that up. You know, don't do bad claim things.
Sure.
I mean,
Behave and be nice to your policyholders.
Exactly. It was like way general. And a lot of it had to do with selling insurance. And it was a lot like we respond back to the insured and blah, blah, blah. And this is where the agents can get tripped up in some bad faith claims. In that particular instance, like not responding to your policyholder when it is reasonably expected that you should respond, quote unquote, that sort of thing. Not that I think most agents don't because they're getting their commissions. So that's a whole different thing than what adjusters usually do. We're paid by the hour or salaried or whatever. So what I mean, we don't want to ignore people, but I think agents or brokers or producers really, really don't want to do it. Anywho.
Well,
So
agents, bad faith applies to many different industries, not just insurance and
true.
not just claims, not just insurance as a whole, like underwriting, but also other businesses. So if you have a landlord tenant situation, there's opportunities for either or both of them to conduct themselves in bad faith as well. And that's just being dishonest about things, taking unfair advantage of people, all those things. So when you think about bad faith, just being someone who's really misbehaving to their own benefit, that's kind of what it is. And then when you extrapolate that down or distill it down rather to the claims operations, when you're a claims professional, you can really see how there could be opportunities for people to act badly on the claim side of things. And there, ample opportunities for people on both sides to act in bad faith here, insured policyholders as well. But let's face it, the insurance companies are the one writing the policy, contract of adhesion, so they're the ones that are going to have the burden, the greater burden of avoiding bad faith scenarios. And you had laid out the history here. As far as the unfair trade practices laws in the 70s, that
Mhm.
was kind of a broad approach. Uh, Again, that's why I bring up the fact that bad faith can happen in other industries. And I think
Yeah.
back in the 70s, they were just kind of getting their brains around how to apply this to our industry. And then, so then the NAIC Model Act, what can you tell me about that?
Okay, so that one is one of the ones that we as claims adjusters are more familiar with. That was passed in the 90s, I believe. And if you ever Google it or whatever and pull it up from the National Association of Insurance Commissioners, NAIC, it'll say Act 900. And then there's also a Act 902. We'll get to that in just a second. And again, all of these very much confused me because I believe the unfair trade practice is Act 800. I was like, what in the world? I mean, because they really do have some of the same languages. Anywho, the claims people felt that we're special, as we are, as we are. And we said we need to have basically our own rules. Like these are our own rules. And
It's not enough to just say act properly in the execution of your job as a claims adjuster. We
right.
need to get more specific.
Exactly. And I think this is where we came up with about 10 or so, 11, 12, somewhere around there. That is the failure to communicate timely, explaining insurance coverages, and failure to pay a claim timely, or failure, or when you deny a claim and you don't quote the policy language. I mean, these are all of the things that we've heard before. Well, then what happened, as is always the case, is that health insurers booger everything up. I'm just going to say it. Health insurers booger everything up. And so then we said, okay, we want our very own rules, the
Hmm.
property and casualty side of it. And so we made the Model Act 902, and several states have adopted 902. Several states have not. Some of them are still going with 900. Some of them go with 902. Arkansas happens to be one of the ones that go with 902, which specifically talks about property and casualty. And that was done in 97. And this is where you will see about three or four more lines added, and that's where they start talking about the anti-steering issues, automobile issues, whereas Act 900 didn't have any of that. So,
Yeah, and by steering, that has to do with collision shops and things like that.
yes,
Insurance companies directing people to go to shops of their choice rather than where the policyholder might want to take it themselves.
yes. So, fun fact also, little fun fact is that again, the industry is changing. And I have my issues with preferred vendors, but that's neither here nor there. We still have all of these anti-steering,
Mm.
meaning the insurer, the carrier can't steer or direct a policyholder to a repair facility, either in homeowners or in auto. However, I have seen the policy provision where it says for a reduced premium, you agree to take our repair people.
Right, which
And
sounds a lot like you're steering them somewhere.
it does sound a lot like you're steering them somewhere, but I think they get Not okay, let me reword this before I even say it. I think they are allowed to do this because it is a contract between the insured and the carrier, and presumably the insured would know that they're signing on for this.
Right.
Also, I have also seen it where for reduced premium, you go with our vendors, but remember you have the choice of vendors. So if you don't want this, you need to tell us. And I've
Yeah, that
seen
doesn't
that.
sit quite right with me. If you're offering a discount in premium so that, yeah, like the big issue is going to be OEM parts
Mm,
or not. I
mm,
mean, that's probably the biggest issue that you're going to run into when you're comparing a collision shop that the insurance company is recommending versus somebody else. And what you're kind of doing is bribing the insured into the use of, you know,
mm.
what some people consider substandard parts. So
Yes,
I don't have any skin in that game because we don't handle those claims here. But
I
uh,
did an article for Bankrate about preferred vendors and bluntly stated my belief because I could do that at Bankrate. And which is that I don't particularly care for them because I can do it on the podcast too, because whatever the policy says is what goes. I mean, if that's what the policy says, then that's what you got to do. So don't quote me like all you other attorneys trying to like retain me and go, gotcha, because that's what you said on your podcast, blah, blah, blah. No. Anywho, what we're talking in this particular instance is that we can go in there and have these vendors, and the history of it is just like the health carriers where they have preferred doctors. That's how the property and casualty insurers got the idea. Oh, well, if they can have preferred doctors that someone can go to and we pay them a lower rate, then we can have preferred shops. That's how that all started with the preferred shops. And
interesting.
yeah, yeah. So there you go.
Well,
Anyway,
the preferred contractors have similar problems. I
mm,
recall, I don't remember the case specifically, but the trial was on YouTube, so I watched it.
oh,
And it was a carrier that assigned a contractor, so it was like a preferred vendor thing. And it just got way out of hand. It was the claim and the repairs were so badly mismanaged by both the carrier and this contractor that and it wasn't a bad faith case. I think what it was is I think it was around mold coverage
ah,
and the delays in the contractor's, performance are really what caused the problems to arise. Anyway, my theory is if you're in the business of insurance, stay in your lane.
yeah.
You're not a collision shop. You're not a contractor. Don't try and fix houses. Don't try and fix cars. Your job is to indemnify for those damages. And if you're going to find ways to cheap out on it so that you can save money, I think that's a little shady. And if you're going to bribe your policyholders by giving them a discount, I think
Yeah.
that's pretty shady too.
Yeah.
That's my opinion.
I, this is one of the ones where you and I agree. We actually agree. And in this particular instance, I know what the carriers are doing. You know, they're trying to control that loss adjustment expenses, and we're getting way off topic, so we got to go back.
Yeah, yeah,
However,
yeah.
however, it does tangentially apply to our bad faith talk. And that is adjusters, be aware of what's going on in your state. If you have anti steering rules, what your policy says. I always found it difficult being an adjuster when I handled auto claims because invariably the insured would say, I don't know where to take my car to get it fixed. Where do you suggest? And I would always, if I absolutely positively could not get out of it, like my feet were being held to the flame, I would give them three choices. And you have to pick. It's your car, but here are three choices. I'm not saying, and of course, I documented the claim file saying I did not recommend anything. I gave them the three choices. So, anyway, okay. So we're talking about handling claims under these unfair and deceptive, and I can see why it would be considered that way because I've seen a couple of bad faith claims come through where the initial remediator, according to the policyholder's belief, has quote messed up end quote the the property because they didn't do their work right.
Hmm.
And so, however, on the flip side, I do think there's a call for sending a remediator out immediately. Okay, we're off topic. Okay, so anywho, hey, we're going,
Hey,
we're moving on. This
right
is like
on.
a whole nother topic, a whole nother podcast topic. Okay.
Yeah, because well, yeah, because you go down the rabbit hole of
Mm,
deceptive contractors, deceptive public adjusters, and attorneys and lawsuits against insurance companies, and
mhm.
that'll be a whole other podcast. So,
Yes, whole nother podcast. Okay, so claims handling rules can live under the Unfair and Deceptive Practices Act. We do have our state because states are the ones who contract with or who control insurance. So each state is going to be different. And I don't know if I did mention, by the way, those states that don't follow any of the model acts, some of them are like Washington, D.C., Iowa, because Iowa's weird. I mean, I can say that I'm married to an Iowan, Nevada, Oklahoma, and Alabama. Oh, Mississippi. Mississippi is weird too. So, I mean, come on. So those are going to be some, and actually, I'm going to talk a little bit about Oklahoma in a bit because while they don't follow some of the model acts, what they do is they have in their statute some of the things that, for example, Kansas or Arkansas has as an administrative rule from the Department of Insurance, which is again one of the things that I learned about when I was doing all this research. So, yay.
seven claim handling standards.
Hmm.
So we've got seven rules here for adjusters,
Right. And
and
like I said, I think there's like, I don't know, 11, 12, something like that, but they can usually be boiled down into seven.
for preliminary claims handling, what do we do?
You just,
We
you got to investigate promptly. You don't let it sit for, I don't know, weeks on end.
Right.
And I know of an insurer, and I cringe whenever I talk to this adjuster. And this adjuster is telling me how their company doesn't have their own IT system for claims. And so it costs $500 or whatever to have the third party people update their claim system, right? And so they wait until the end of the month and give them all of the IT tickets at one time to update. And that means adding a new customer or writing a check or whatever. And so this adjuster can get a claim, but the claim doesn't even come into the claims system because that, let's say, client hasn't been input yet, or they don't
Wow.
have the correct data fields and they have to get IT to add the data fields. And so we're already a month late. So
Hmm.
the adjuster is, do I start adjusting and keep notes somewhere else?
Right.
Kind of cringy.
Yeah.
Or do I not do anything until it's all set up? That's very bad. So, and I just sit there and scream at his employers who can't hear me, excuse me. Oh my God, fix it immediately. Ah, you have no
Well,
idea.
you and I probably came up in an age where paper files were kind of the primary way to
Yeah. Yeah.
manage a file,
Yeah.
and all of our written notes and everything went in there, and the communication on screen was just kind of administrative. It wasn't
Mm,
really considered the claim file
hmm.
until, oh, probably. not too long after, say,
2000s?
98,
Mm-hmm.
99, that around that time is
Yeah.
where the
Mm-hmm.
system started to get a little more robust, where
Yeah.
you could put all those things in there. I think our first digital cameras came in around 1999. They were around before then, but
Right.
they weren't generally used for claim purposes until around 99, from
'Cause
my
they weren't very
experience.
good.
They were slow, and they were
Yeah. Pixelated.
low quality, and but
Memories
yeah,
running through my foggy mind. I don't even know the words. Okay.
I don't even. I do now.
Oh, no, I don't know those. I don't know if those are the words. I just know that memories. Claim procedures. Okay. So this is something that I really do not see in a lot of files. And and I mean as an expert witness. And the carriers will swear up and down that they have management oversight
Okay,
of
first to
this.
clarify what it is, though. Claim procedures
Oh,
means
oh, like adjusters are
the
trained and there's management oversight,
right.
right?
So
And okay,
document your training and
yes,
document that a manager has been in the file and is watching what you're doing.
exactly. And I'm more speaking to having management supervision because I could probably count on one hand for my expert witnessing career, which is only 6 years, but how many times I've seen a manager in the file. Now, I've seen something that's, as the kids these days say, super sus, which is suspicious, where I will get this file and there's the adjuster's notes, and then in red, there's the manager notes. And I'm thinking, that kind of looks like you added that a little later. I don't know. I'm just saying I don't know. However, we have to have management supervision. So if you have that round table, like I will see an adjuster note saying round table with so and so, but so and so doesn't also have their round table notes in there. Now, I get the fact that we want to keep our round table notes usually very general, because there's stuff that we're talking about. But you would say roundtabled with Tom, Dick, and Harry, we discussed reserves and bodily injury of plaintiff. Boom. That's what you talked about. And then Tom, Dick, and Harry need to be putting their notes in there. Had a roundtable with Dick, Harry, and Jane, blah, blah, blah. You see what I'm saying? And
Yep.
so those notes need to be in there. And so often I don't see them unless there is a complaint. And which is, insured called, I returned their call, told them that the claims adjuster's doing whatever and blah, blah, blah. That's not it. You're supposed to be overlooking, and not just once or when the file's closed or whatever, but that would really keep people from getting off the tracks, so to speak.
The when you say management, heavy management supervision, so define that versus somebody, a manager getting in the file and maybe giving some direction.
I think that is the management supervision.
Okay.
The
Okay. I
um
thought you meant maybe you were talking about something else, like overall.
no, no, I think
Um,
I'll give you an example what we used to do at ARM. And this wasn't in the initial note, but when we would assign a claim to the adjuster as the manager, we would send the adjuster a note along with the claim setup people. We're like, okay, this is a general liability claim. It says slip and fall. You need to do a recorded statement of the insured, of the claimant, of the witnesses, get cleaning logs, get any film or camera, da 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 da, blah, blah, blah. And we would tell them what to do.
mhm.
The file's not set up, so we can't necessarily put that back in the file yet because we're giving them instructions prior to the file. However, then what we would do is 7 days after the file had been open, we're doing our, as a manager, first report review. Has the adjuster reviewed and explained the policy language? Yes, no. Are there any coverage concerns? Yes, no. What are they? I'm seeing the insured, I don't know, um, has a endorsement that says they have to clean it every hour and they didn't do it. So you need to send out a reservation of rights letter, except in New York where you would send out a, what is it called? Um,
Conditional disclaimer.
yeah,
Well,
yeah,
we would. I don't
disclaimer.
think we would for that necessarily. Well,
Anyway,
we
you know
might. You
what, or
never know.
late reporting, or I don't know, something. You know what
At a
and like
minimum, we would get a non-waiver.
yeah. And we would be, oh, okay, it's late notice. Let's do that. Late notice. Oh,
Okay.
you need to send out ROR for late notice because this happened 8 months ago and I don't see you doing that anywhere. Did you explain it? And then in 30 days, we're sitting there going, why haven't you done this? Why haven't you done that? What is the answer to this? What is the answer to that? Have you thought about doing XYZ? Because as someone who has 25 years experience and someone who has 5 years experience, I'm trying to keep them on the track without going off to the side. And I can tell you, I've had younger adjusters come up to me and I've read the insured's correspondence and I said, there is an attorney back there somewhere because that person doesn't know those words and they are pushing all of the right buttons. So they are getting ready to set us up for bad faith. And we need to be very, very careful here
Yep.
because they're talking about blah, blah, blah. And da, da, da. I mean, they're pushing all of the bad faith buttons.
Yep.
And so you can see it coming a mile down the road. And then this is how you would cut it off. One short other example of a case that I'm working right now. The insured, maybe a little unreasonable and a little mm, self-centered. Ah,
You're
and
waffling here. Just say it like it is, Chantel.
well, it's an active case, so I don't want to
Okay.
go too far. But a concrete example, I mean, the adjuster's father died, and the insured actually wrote a letter or an email into the carrier saying, "I don't care. Why isn't my claim being handled by someone else?" And I'm like, "Wow,
Mm.
okay." Anywho, uh, so you got that, but then no one responded to it
Mm.
from the carrier side. And that antagonized the insured even more
Yeah.
because then the insured didn't feel heard. And this is,
Antagonism goes both
it
ways.
does go both ways. And so I think that's one of the next points is communication. It has to be timely, clear, forthright. And I have skipped one, but that's okay because it kind of bleeds into this and easy to understand. And usually you have to only respond to things that reasonably need a response. So if the insured says, I don't care that my adjuster's father died, what's going on with my claim? Do you need to respond to that? I don't
It could have been
know.
asked better. It could have been,
Yeah,
I'd like to, I'm sorry to hear about the passing of the adjuster's father. I would like to get a status of my claim.
right.
That's one way to handle it too. Um,
True. But the point is that even acknowledging the insured saying, I understand that you are impatient to find out the status of your
mhm,
claim as diplomatically as possible, then she or he would at least feel heard.
right.
And that's part of the communications aspect. And it has to be timely, clear, forthright, and easy to understand.
So that's number four. It's just to summarize where we are in these seven rules. Preliminary claims handling, be prompt. Claim
Yes.
procedures, you have trained adjusters that are managed. Investigations tailored to each claim, meaning that You're
Right.
not going to just have a boilerplate list of things to do for every claim. We need some guidance, and you have to be kind of tailored to the situation at hand. And then communications must be timely, clear, forthright, and easy to understand. There's three left here.
I know, but I want to mention one thing because I was
Sure.
doing a little, uh, I'm trying to make an assignment for my risk and management students 101, basically, because a lot of them are just saying, well, why don't we just plug in the policy into AI and let it tell us what coverages are? And I said, you know what? That sounds like a great idea until it's not because it hallucinates. It eats shrooms every once in a while
Hmm.
and that sort of thing. So maybe not a good idea. And I had come across an article that talked about an insurer. I won't mention who it is, but they were using AI to write all the letters,
Mm.
their 30-day letters. And the quote was, the adjusters are too busy to write it, so we're having AI write it. And I'm like, oh,
Mm.
oh. And that was actually from a spokesperson.
Mm.
And I'm like, oh, this is while true, while true. You don't say that. But also, they were, the spokesperson actually said the reason they're using AI is because when humans, adjusters, wrote the letters, the 30-day letters, it was too complicated with too much insurance jargon. And what the adjusters are
Well,
supposed to be doing is using AI to write the letter, review it, make sure that it makes sense, and then shipping it off. But they're not doing that because adjusters are too busy. So, anyway, FYI, it's got to be clear and easy to understand.
yeah, yeah. So they were trying,
They were
um,
trying.
trying to address that piece of it. So kudos to them. You know, right, having AI write the communications to the policyholder. If it's a general communication, like we've received your damage estimate and is currently under review, that kind of thing, I don't see a problem with that. If you're relying on it to make heavy-handed decisions about coverage
Mhm.
or damages, I think that's going to get you into hot water pretty quick.
It has been. Let's talk about momentum because this is where I see it most often, where things usually go off the rails.
Hmm.
Adjusters are busy. We all know that. And there should be no unexplained delays in the claim file, right? Your dad dies. Okay. I mean, you're not going to put in every single claim file. My dad died. I'm taking a week off. You're not going to do that.
Hmm.
But there shouldn't be 3 months of no file activity for nothing.
Right.
Again, another example would be, let's say our date of loss is April 1st and you're not cutting a check until December 15th. Why? Why? This is my first question. Why did what, 8 months go by without, I mean, and there's nothing in the letters, there's nothing in the claim notes that says why. You're also not making a decision slash resolution or analysis, which is the next one, analysis right after momentum, because that's you're documenting damages and applying them to coverage. Because by the way, you got to look at coverage 5 or 6 different times in the claim file. Every time you get a new piece of information, you're
Sure.
looking at coverage
Yeah.
to see how things change. It's not
Yeah.
just the first day.
Momentum just means primarily demonstrating that you are working the file in
Mm-mm,
some way. That it doesn't mean you have to settle the claim
mm-mm.
within a certain time frame if you don't have the information, but at least show that you're doing something to get the information. We have a lot of cases that linger because somebody is continuing to treat. And our file is open for 6 or 8 months sometimes, and the attorney just ignores us. What are we going to do? Document the file. We
Yep.
tried, we left messages, send another follow-up email. It's the best you can do. Um, but that's a reasonable delay because this person is not ready to finalize their claim yet. They're still recovering from a very bad injury, you know. So anyway, that's momentum analysis. So that comes to documenting damages and applying the coverages.
Mm-hmm. Yeah. And I mean, I think that's kind of self-explanatory. You get that estimate in or whatever, and you write that down in the file, and then you apply the analysis. Is there coverage? Is there not coverage? Why? Why not? How much are we going to pay? And then that leads right up into sometimes into the same file note of what your decision is. Yes, I'm going to pay. No, I'm not going to pay. I need to deny the claim. And again, it it needs to be a lot more detailed than what I am now seeing in claim files. Because a lot of times, what I am seeing in claim files is got the estimate from Jane Smith, the independent appraiser or field appraiser or whatever, and it's for blah, 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 $1,000, sent out a proof of loss and letter to the insured. That doesn't tell me anything. Is it covered? Is it not covered? Why? What's the deductible? So usually what you should be doing is got the estimate.
Mhm.
It's for location number one, which is da 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 da. There's coverage for that one in this policy, and because again, you're looking at coverages, and then you go in. Estimate is for $1,000. Everything is within coverage, like there's no mold that would have a mold exclusion or I don't know, whatever. And less your $5 deductible. So I'm going to write a check for $995 to the insured, Mr. Insured, Mrs. Insured, and mortgage holder, and sending them a letter and a proof of loss and blah, blah, blah. And then you pick up the phone and call them and tell them all of that too. So that's the difference. And I will explain this. There is a reason why I'm harping on your claim note being that detailed. I'll get to it. I promise. I promise. Um,
So the
yeah.
one thing I would add to the analysis line is liability.
Yeah. Yeah. Oh, yeah. Yeah. Well, if it's liability, absolutely. Yeah.
Yeah, so you have to analyze liability, analyze damages, and then see how all of that fits into coverage.
Mm-hmm.
And when we talk about liability versus uh, coverage on third party claims, that's an important conversation to have both with the policyholder and with the actually with the claimant as well, so that they understand. Look, we're not saying necessarily that the insured didn't do anything wrong here. They absolutely did something that was wrong or negligent. It just turns out that there's no coverage.
There's
So
no
that
coverage.
doesn't mean that you don't have, you know, a valid claim. We wouldn't actually say, oh yeah, you got a great claim. Go ahead and sue the
Oh,
insured.
yes. Sue the
There's no
insured.
coverage, but go ahead. No, we don't do that.
Be our guest.
But that's
Uh,
a dance you've got to do. You've got to have a conversation that's about those facts, and you got to be able to say, okay, here's a situation. We know Mr. Insured did something that may or may not have caused harm or damages to you. Uh, the details of that will be worked out later, and we can't really comment on that. But what we can comment is that what was done here does not fall under a covered occurrence or whatever, and is not covered under the policy. So we
yes.
can't defend the insured and we can't indemnify them for any damages that they might owe. That's the best. It's a lot of words, right?
Right. It's a lot of words.
You say that to somebody who has no background in insurance claims. They're going to be like, "Why are you talking to me like you're a lawyer? I
Yes.
don't, why don't you just tell me straight up what you mean?" And there's no easy way to do it because this is kind of a complicated business. Um, anyway,
I
that's my
have
aside on
thoughts.
analysis.
I have so many thoughts. No, and I love this that you said that because it brings up a very good point, and it's something that I tell my students. showing them that even I am human.
Mhm.
Is that Professor Roberts, it probably took me a good 10 years, even though I knew it innately, I couldn't put words to it, that liability is a two-step process. You have coverage and then you have liability. And unless you have both of them saying yes, is there coverage? Yes. Is the insured negligent or is the insured liable? Yes. That's the only time you would pay. Is
Mhm.
there coverage? No, but the insured is responsible. You don't pay because there's no coverage.
The insurance company doesn't pay.
Well, the insurance company doesn't pay.
And
Um,
that's the distinction that a lot of
a
people
lot of it,
can't
and a lot of
get
people
that
don't even know.
break.
Right.
They don't. They think they're suing the insurance company.
Right. And the thing is that so many consumers don't understand it as a two-step process. So even if the adjusters don't understand it as a two-step process, think about the consumers.
Hmm.
And to answer your question about you're using all of these big technical terms, I always, when I'm speaking again to my students, I do this. I use the insurance word and then I use the common everyday word. Subrogation, I mean reimbursement.
So how would you
Indemnity,
describe
I mean payment.
describe indemnity in I mean
It
indemnity is not terribly
it is hard word.
complicated, but
It is a hard word.
how would you kind of simplify the word indemnity when you've got contractual indemnity between a landlord and a tenant, for example, and you've got to explain that concept to someone
Mhm.
who's not an insurance person. It's not easy to do all the time.
It is not all the time easy. And that's when you would go, okay, so you've signed a contract that says that you are going to indemnify, which means pay your landlord if something happens to the property. That's how I would do it.
This is the word game we have
Yes,
in this job every day.
absolutely.
Is it's not just that word. They're
Oh,
look at the
there's tons.
policy, you know.
Oh, there's tons. Like even explaining liability. Oh, you're
Mhm.
liable. You're negligent. Well, okay. Anyway, let's move on.
Move on.
But by the way, this does go to communication and being able to speak plainly and in a term that's understandable, which
Right.
is again why it's easier to have these phone conversations and then maybe put the letter a little bit more formal.
Right.
So anyway, I'm not going to go over timing and stuff because I think a lot of people do, and we're probably running out of time or whatever.
Yeah.
Uh, but
We should put your seven claim handling standards in the show notes.
oh yeah, yeah,
That'd be a
yeah.
good idea.
Okay. And so we all know as adjusters that there are timelines that we have to meet and deadlines that we have to meet. We have to pay within 30 days, or if we can't do that, like what Bill was saying, you send out a letter, and I was talking about the 30-day letter. So what we also need to do with our issues, again, making sure that our file is properly documented and everything. I'm going to kind of skip or combine number 6 and 7 for us, Bill, since we're kind of
Okay.
running out of time.
Sure.
I wanted to talk about Oklahoma. And this is part of the thing that I learned about when I was, looking into this Dallas talk that I was doing. And so Oklahoma has a statute because remember, Oklahoma doesn't adhere to the model laws. They have their own gigs. And one of the statutes in Oklahoma is that an insurer's claim file shall be subject to an examination by the insurance commissioner. Every single law in every single state that I've ever read has that rule. Okay.
Hmm.
Whether it's in the unfair trade practices, unfair claim settlement practices, whatever. Such files shall contain all notes and work papers pertaining to a claim in such detail that pertinent events and the dates of such events can be reconstructed. So let me tell you what that means. That does not mean copy the email that you just got sent and put that all in the claim file. full. You put the email into the claim file, but you don't cut and paste that email. What they're talking about in such detail, pertinent events, that such events can be reconstructed, what they're talking about is your mental interpretation of that. So that if you got struck down by a bus, God forbid, we could pick up the file and handle it. So, insured sent in paperwork concerning the painting of their garage, and they wanted it to also be hand stained. This is, again, an amalgamation of a bunch of claims that I've
Mhm.
seen. And what the adjuster did was send out a very, very wordy chain, it was just words, basically. There were words in this
Lots of
email.
words.
There were lots of words, and you had to read it 3 times to figure out that what the adjuster was saying is we will pay to paint your garage, but we will not pay to hand stain your garage. Okay, so if you think about that, we will not pay to hand stain your garage. That's a denial. Or maybe not a denial, but because there's no policy language, or there is, it says that we're going to pay reasonable repairs. And the adjuster felt that hand staining the garage was not reasonable. However, how do I know that? Because all of the notes say got email from insured repainting and hand staining not warranted, sending email to insured about this. That's it.
Hmm.
There's nothing in there that says policy language states that we will pay reasonable repair cost. And I believe that this can be repaired via painting, not hand staining. Therefore, I'm going to send out a letter explaining this. Maybe not a denial, maybe a reservation of rights letter. I don't know. But you need to do something more than a rambling email that denies a claim. And you need to do more than, this is not warranted. I'm going to send out an email to that effect. Why is it not warranted? I don't know.
Right.
You need to tell me. And that's what the Oklahoma statute says. Okay, so this leads to the next thing, which is that, of course, as we've talked about, every state has their own departments of insurance. The departments of insurance, being a governmental entity, have their own codes of enforcement. These are called administrative codes. And this is where you will see in those states, like in Arkansas, that have already gotten the model acts into their statutes, you also got to go to the Arkansas Department of Insurance and look up their administrative codes for claims handling, because that's where they're going to say, put in what you're thinking right now.
Hmm.
And so that's where you can get tripped up as well. So, brand new set of rules. Who knew? Oh my gosh. Yay.
Well, so you're saying that you have to not, it's not enough just to put the documentation in the file. It's you also have to demonstrate that you understand the documentation, and then you've got to be able to also communicate the decisions that you're making on the file,
Yes.
not only in the file, but to the policyholder in a way that everybody can understand.
Yes.
Okay,
That's what
we
I'm
can do that.
saying.
Good
Yes.
job.
Yes. Thank you for summarizing that, because it's a lot. And it is, I don't know,
And this is governed by statute. You're not just
yes.
making this up. This
No.
isn't just um,
Or it's administrative code where the DOI can go, yeah, I'm going to take away your license.
Right. So we have Regulation 64 here in New York. We've
Uh-huh.
got insurance law, the 3400s, that all dictate, the timeliness things
Mm-hmm.
and unfair claim practices and all that stuff. Um, so yeah, and you've got to be familiar with them. And if you're a manager, or if you're running a claims department, you have to make sure your people know this stuff.
Yes.
And it needs, have seminars, have your weekly meetings or monthly meetings where you just carve out 10 minutes to talk about something from those regulations so that everybody, and then document that you did it so that you
Yeah.
have a history because you don't want the only history that you don't want to be in a situation where the only history that you have in your claim files is a consistent lack of attention to detail.
Yeah. Yeah.
Notes missing, delays. If all the documentation you have supports that, and you don't have any documentation showing that you are consistently trying to teach your people how to conduct yourselves within the laws of your state, it's going to be a problem, and you don't want to have a problem.
It is. And then I hate to say it because I don't want to, you know, throw anyone over or anything, but if you're having these regular training events and you've got that one adjuster who just is not doing it, then you've got a rogue adjuster. And
Right.
that adjuster needs to go because that adjuster is going to
Or
get
be retrained,
or be recalibrated. Well, I mean, sometimes you just can't retrain them and you just need to let them go. But here's after I say all of this, I do want to give a closing kind of thought because I think that I try to do the whole gloom and scary and all of this kind of stuff. But remember when we started off, you as an adjuster and even as an agent have the right to be wrong as long as, and you had said it, Bill, as long as you're not acting with dishonesty and being willful and being malicious and being just hateful, just like you were talking about with all of the industries, not just ours, that's when we started to get that history. You said it really, really well. So you've got the right to be wrong. You as an adjuster can make the wrong decision, and they
yeah.
can sue you for bad faith. Which is when I get involved and I'm like, yeah, no, they're okay, or oh yeah, they totally messed this thing up.
They did
And
the best with the information they had at the time. That's what you want to strive for, is
exactly.
that somebody's going to say, you know what, Bill made a bad call here, and something went south on it, but he didn't know all of the stuff we know now when he
Right.
made that decision.
And that's why I'm saying too, if you just have a claim note that says hand staining not warranted, well, why? I
Hmm.
don't know why. So I think you can be being malicious or hateful or ugly or whatever.
Hmm.
But if you sit there and go, I think that actual painting will be fine because of the age of the wood, or yeah, I think mechanical sanding will, whatever you think, put it in there. You can be wrong, but it won't be as bad. You can make a
And
mistake.
and what I had just said about, not having the information at hand, maybe you
Yes.
should have, maybe that's not an excuse. Maybe the information that you didn't have, you should have had because of training or because of, were you just being ignorant and ignoring whatever? On your staining
Yeah, on the
example,
staining example. Yeah.
is this a person who has zero experience with wood and stain and
Hmm.
doesn't really know that staining wood is a thing and never heard of it before because they lived under a rock?
Right.
Um,
They live in a brick house versus a wood house.
right. I mean,
But but you're
maybe
absolutely
they
right.
should know. Uh,
And then they go, well, and making that note, that claim note, detailed claim note. I spoke with Bill, who is a claim, who is the field adjuster, and he stated that blah 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 blah. So I'm going to blame
mm,
you. But at least I'm making my decision based off of advice. It's kind of like making a coverage decision based off of advice of counsel. It could be wrong, but that's what you did at the time. Okay.
we have a lot of high stakes cases involving the need for various subject matter
Mm,
experts.
mm,
And the reason we need those experts is because, um, like I said, the information that we need to make the decision, we can only guess at now. We
right.
can Google it, we can watch YouTube videos,
Mm,
we can plug it into AI, and we
right.
can get all the answers that we think we need to make the right call. But without like an expert telling us really the facts as that expert sees it. We're just guessing.
Hmm.
And and in those scenarios, it's beholden to the insurance company to to get the experts they need to make the right decisions. Because
Absolutely.
I do see a hesitancy to spend the money on experts or
Getting them in too late.
just kind of write it off as if it's not a big deal.
Hmm.
Everybody can see this is plainly the fact. Uh, okay, are you an expert in that kind of injury? Do you really know that they should have healed in 4 weeks instead of 8?
Mm.
Um,
Yeah, because what if you have an eggshell plaintiff?
mhm.
Yeah, I mean,
So my point in that is you do have the right to be wrong, but you have to be really careful with that and
yes.
make sure that you're not in a situation where you're just kind of shrugging your shoulders and saying, oh, well, I guess I was wrong. I didn't know.
And again, I would point out again, this is where your claim notes say, because this is where your logic is. It's not, I'm going to do this because I think, because, Dr. Google said blah, blah, blah. It's,
Right.
I'm going to do this because counsel said to, or I'm going to do this because the field adjuster who talked with the roofer told me XYZ. You are explaining your logic. And then if that logic is incorrect because you've relied on wrong information, that's it. And if you need, or I'm going to do X because I hired an engineer and the engineer said XYZ.
Hmm.
That's what you do. I mean, that's when you rely on that aspect. Yeah. So claim notes, also
Claim
bad
notes.
faith. All about communication and documentation and decision making and all of that. It'll be in the show notes. Anyway, like, comment, share, subscribe. Tell us about your worst claim thing. Tell us about your bad faith claims. Tell us about an idiot claims adjuster. I don't know, whatever. Tell us something. I just like
Tell us
whatever.
stories.
Tell us stories. Tell us if you like these darn adverts that I make. I don't know.
Yes. You know what?
I'm trying.
So the when we do these episodes, the most feedback that we seem to get is on LinkedIn,
Yes,
which I encourage. I think
I
that's a
do too.
great platform. You and I are there all the
All
time,
the time.
commenting and having fun and promoting what we do here. So if you are on LinkedIn, please follow both of us.
Mhm.
Uh, Reach out and say some kind words or ask a question if you've
Yes.
got a question about anything we say here.
And be sure to like the adverts that we're doing, because
Oh yeah.
LinkedIn's algorithm doesn't like us self-promoting, so FYI. But if you like and subscribe and comment on Spotify and YouTube, that does push, the algorithm does push up on things. Okay, so our next episode, by the way, is January 15th. It's the anatomy of a slip and fall claim, which is super exciting. I can't wait to hear. No, I'm serious. I can't wait to hear some of your thoughts, because
Oh, we have so many fun things to
we
talk
do. We
about.
have so many fun things to talk about
We
on
have
that.
I don't think you can you see this paper
Yes,
on
the
the door over
board.
here?
Uh-huh, uh-huh, uh-huh.
That is our Espinal cheat sheet. Espinal is a case here in New York that
Okay.
relates to snow removal contractors
Oh
and
yeah.
their
Yeah, yeah.
liability. So
Okay.
yeah, lots. I could we could do 3 or 4 episodes on slip and fall
We
cases,
can.
especially after last year.
Oh
Um,
yeah. All right. Well, think about your New Year's resolutions. Make them to be big claim notes and everything, and management supervision, and I don't know what else.
Go out and enjoy the
Yes.
day off today,
Yes.
January 1st, right? And
Absolutely. We'll
kick
see
off the new
you.
year.
Yeah, we'll see you on the 15th.
All right, take
Bye.
care. Thanks for
Bye.
joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.auten.claims. And for anyone interested in working as and independent liability adjuster. Go to the Contact Us tab to join our roster.
In the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.